a total of 5 minutes to be. Is this to be divided, Senator Beamers, among anyone? Or is it just
Yes,
Mr.
we
Mayor?
have one more witness.
Okay, to
after
be
this.
divided between yourself and one other witness. Thank you.
There, make sure I'm on. So I only have I have 2.5 minutes. Is that what we're saying?
However you like to divide up the 5 minutes. Yes, those are our
Mr.
committee rules. Thank you.
Mr. Chairman, I think you told me yesterday they would have 5 minutes each.
I'm sorry, Senator Beavers. Our committee rules are 5 total minutes among all presenters on a side. Those are our rules that we announced at the beginning of the committee this year in January. But we can't. They can take questions afterward. I assure you, though, there will be questions. I assure you. Senator Bell, you.
Mr. Chairman, those are the clearly stated committee rules that you stated at the beginning of the year. There does seem to be, and I didn't know this until she just said it, a misunderstanding that she thought that you told her yesterday that
Without objection, that is so ordered, and you're allowed 5 minutes, Mr. Maharrey.
Okay, I appreciate that. Thank you very much. My name is Michael Maharrey. I'm the National Communications Director for the 10th Amendment Center, and I'm very honored to be here with you guys today. I'm going to address the Attorney General's opinion on this particular bill. As you probably know, in the opinion of Attorney General Robert Cooper, SB 250 violates the Supremacy Clause of the Constitution. And I've read his opinion, and his basic reasoning is very solid. Nevertheless, he came up with the wrong answer. Now, I'm sure you guys all remember working those long quadratic equations back when you were in high school algebra class, and you know that you can work all of the steps absolutely correctly, but if you do an addition or subtraction error in your very first step, you're going to come out with the wrong answer. Why? Because you've worked the problem working from the wrong premise. Cooper spends the bulk of his opinion correctly arguing that constitutional federal law trumps state law where it conflicts. Quite frankly, that was a waste of time. Nobody disputes that. The problem is that he incorrectly assumes that every federal act is constitutional law, and he builds his opinion on this fallacious premise. Fact, only laws made in pursuance of the Constitution are truly supreme. All of the founding fathers agreed, and I mean all of them, that any federal act that violates the Constitution is no law at all. Hamilton summed it up in Federalist 78. He said, every act of delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution can be valid. Cooper apparently wants the people of Tennessee to believe that the following federal acts mentioned in Section 5B of SB 250 are constitutional and therefore supreme. A ban on firearms, tracking of ammunition, federal taxes on firearms accessories, among other things. Where exactly does the Constitution delegate the federal government power to regulate firearms? It doesn't. Now, some will argue that there's some regulatory authority under the Commerce Clause. But we have the Second Amendment. And the Second Amendment puts further restrictions on the federal government. And we have to keep note of the most important phrase in the Second Amendment, shall not be infringed. Infringed means to interfere with. That leaves no wiggle room. Now, Cooper mentions the possible unconstitutionality of these acts almost as an afterthought. He writes near the end of his opinion, while the bills themselves declare that certain federal firearms regulations are unconstitutional, the responsibility for that determination rests with the judiciary, not a state legislature. Now, the Attorney General rests his argument on the Marbury versus Madison case, and I know we've talked about that in this committee earlier. But Cooper is misconstruing the Marshall ruling. Chief Justice Marshall was merely asserting that the court can, in fact, nullify an act of Congress by ruling it unconstitutional. Nowhere does Marshall assert that the court has exclusive authority to rule on constitutionality. In fact, quite the opposite. He wrote this: the particular phraseology of the Constitution confirms and strengthens the principle that a law repugnant to the Constitution is void, and the courts, as well as other departments, are bound by that instrument. Now, the Attorney General also cites Cooper v. Aaron to assert the supremacy of the federal judiciary and that its rulings cannot be challenged. That case also rests on this same bastardized interpretation of Marbury. Such a notion obliterates the constitutional system, making the court the de facto sovereign. I shouldn't have to point out the absurdity of the court making itself supreme. It's like King Arthur claiming supreme executive authority because, in the words of Dennis and Monty Python and the Holy Grail, some watery tart threw a sword at him. Ronald Reagan, Attorney General Edwin Meese, said this about the Cooper decision. He said, the logic of Cooper versus Aaron is at war with the Constitution, at war with the very meaning of the rule of law. We need look no farther than the Dred Scott case, which was brought up just a few minutes ago, which denied even free black citizenship and went on to proclaim black people as inferior, to see the inherent flaw in this idea of judicial supremacy. Do you really accept that the Dred Scott was legitimately the law of the land even for 1 minute? Abraham Lincoln certainly did not. In response to the ruling, he said this: if the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Fact, the Attorney General tells us that only the federal court can determine constitutionality. Fact, Ronald Reagan, Attorney General Edwin Meese, Abraham Lincoln, James Madison, Thomas Jefferson all disagreed. Jefferson said this, and I think what we need to do here while we're considering this bill is to try to unravel his logic. He said the states are not united in the principle of unlimited submission to their federal government, and the government created by this compact, the Constitution, was not made the exclusive or final judge of the extent of powers delegated to itself. Simply put, the people of the states delegated the federal government its power in the first place. As Madison said, the states then, being parties to the constitutional compact, in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in the last resort whether the compact, the Constitution, made by them is violated, and consequently, that as parties to it, they must themselves decide in the last resort such questions as may be the sufficient magnitude to require their interposition. Thank you very much.
Thank you. And why don't you just go ahead and stay here if you don't mind, maybe scoot down a chair, or actually you're fine there, and then we'll take our second speaker can come sit beside you as well.
Should I turn this off?
Yes, just press it one more time. And again, thank you very much for being with us today for this very important issue on constitutional issues. And we appreciate your words. We've got 5 minutes. If you would, please make sure your green light is on and then state your name and title for the record. Thank you.
It is on. My name is Publius Huldah. I'm a retired litigation attorney, and I write on the original intent of the Constitution using the Federalist Papers. I do not go by Supreme Court opinions because for 200 years, the Supreme Court has been ignoring the Federalist Papers and the Constitution our framers given, and they have gone off on tangents of their own which have nothing to do with the Constitution. The Attorney General's opinion begs the question. He states that states can't nullify acts of the federal government which are authorized by the Constitution, but then he completely fails to cite article, section, and verse, a clause, where the Constitution delegates to Congress authority to restrict our arms. When we ratified the Constitution, we created the federal government. We listed, enumerated every power we granted to our creature, the federal government. Article 1, Section 8, Clauses 1 through 16 lists most of the powers we delegated to Congress for the government, for the country at large. We didn't put on our list that our creature could restrict our arms. We didn't delegate this power to Congress because our framers pursuant to that, Congress passed the Militia Act of 1792, where they required every able-bodied male citizen between the ages of 18 and 46, except for federal officers and employees, to buy a rifle, ammunition, and report to their local militia for training. Pursuant to Article 1, Section 8, Clause 11, Congress is authorized to issue letters of marque and reprisal. This is what authorizes private warships to make war on our enemies. These were the privateers who fired on British ships during the War of 1812. Our framers contemplated a people who were heavily armed. That is why we never delegated to our creature authority to restrict our arms in any fashion whatsoever. And when the federal government attempts to do so, they are usurping powers which they do not possess. The Attorney General goes by court opinions, not the Constitution. There is a vast gulf between the two. We have 200 years of Supreme Court opinions, and Mr. Chairman very kindly shared some of these 200 years of Supreme Court opinions, which have nothing to do with the Constitution. Charles Evans Hughes said over 100 years ago, the Constitution means what the judges say it means. That has been the prevailing dogma ever since, and generations of lawyers have been indoctrinated with this lie. That is why we no longer have a federal government which is held down by the chains of the Constitution. What we have is ruled by five judges on the Supreme Court who claim the power to do whatever they want to us and our country. So today we have two opposites, what the Constitution says and what the Supreme Court says. Well, your oath of office requires you to obey the Constitution, not the Supreme Court. The Supreme Court is merely a creature of this Constitution and is completely subject to its terms. My third point, the AG asserts that the that the Supreme Court is the exclusive and final authority on the extent of the powers of the federal government. But our framers knew that Supreme Court judges were as likely as anybody else to be corrupt, usurp powers, and act lawlessly. So Congress, the President, and the states all have checks on the Supreme Court. Hamilton shows in Federalist number 81 that Congress's check on lawless federal judges is to impeach them and remove them from office. The President has his oath of office as a check on the Supreme Court. The President's oath is to preserve, protect, and defend the Constitution. It is not to obey the Supreme Court. The Supreme Court was not set up in our Constitution as the superior branch of the federal government. And then there's no need for me to, Madison says in his report on the Virginia resolutions that it is a plain principle founded in common sense that the states, as the sovereign parties to the Constitution, are the final authority on whether the federal government has violated the Constitution, and that the states may check all three branches of the federal government, not just, they may check the judiciary, the executive, and the legislative branches by nullifying their acts. If the judicial branch connives with other branches in usurping powers, our Constitution will be destroyed if we do not stop them. This is what James Madison said in his notes on nullification, in his report on the Virginia resolution. I'm sorry I didn't have time to finish. I hope that during questions, someone will ask me about the so-called nullification crisis of 1832.
Thank you very much for your comments, and we appreciate your staying here for questions. Ms. Huldah, I think you have correctly pointed out that ultimately this bill is not about Second Amendment rights. If it were about the Second Amendment rights, we'd have the NRA down here asking us to support this bill.
It's about enumerated
this bill
powers.
is about constitutionality and who decides constitutionality.
Well, first
So
it's about,
in your opinion, excuse me, ma'am.
yeah,
Sorry, thank you.
sorry.
In your opinion, who decides constitutionality?
Okay, first, I do not have any opinions. All I do is channel our framers, the Federalist Papers and other original source writings. Our framers all said, James Madison, Thomas Jefferson, Alexander Hamilton, among others, said that in the last resort, the states are the final authority. The federal government is merely the creature of the states. The states, as sovereign members of the Federation, retain the ultimate authority to decide.
Okay, so the states have the ultimate authority to decide issues of constitutionality over the federal judiciary, federal Congress and federal.
Right. That is what James Madison, Alexander Hamilton, and Thomas Jefferson
Well, how do you
said.
square that with Federalist 78, in which Hamilton said, by a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and like. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be, to declare all acts contrary to the manifest tenor of the Constitution void. With this, all the reservations of particular rights or privileges would amount. Without this, all those reservations of particular rights or privileges would amount to nothing.
I was hoping you'd ask me a hard question, Mr. Chairman. It is in the first resort the Supreme Court may pronounce on the constitutionality or unconstitutionality of acts. But in the final resort, the states have this power. And if you look at the next paragraph just after the one you just read, you will see where Hamilton says that the states, that the people are the ultimate authority.
Did you
Just in the paragraph just after the one you read.
Did you agree with the opinion of the Anti-Federalists?
Again, I don't have any opinions. All I do is say what our framers said. This is not ever properly a matter of personal opinion. But what did our framers say?
I don't know what they said about this.
Well, I'm telling you what they said about
Anti-Federalists.
I've told you what our framers said about nullification.
Well,
and in my latest paper.
Excuse me. How about, let me ask it in a different way. The Anti-Federalists, Robert Yates, said the judges under this Constitution will control the legislature, for the Supreme Court are authorized in the last resort, to determine what is the extent of the powers of the Congress. They are to give the Constitution an explanation, and there's no power above them to set aside their judgment. That was, of course, written in protest to the Constitution and against its passage, but nonetheless, it was actually giving the sentiments that had been laid forth by the Federalists in the Federalist Papers.
Right. The Federalist Papers were written in part in response to the Anti-Federalists to answer their objections. And many of the Federalist Papers address what they say are spurious objections. So that is a spurious objection. Of course, our Constitution doesn't delegate supreme power. It doesn't invest the Supreme Court with godlike status.
And do you believe that Madison, in your testimony, did Madison believe in the idea that states could nullify federal laws?
Madison has written 2 definitive works on this. His report to the Virginia legislature in 1799 and 1800, and then his notes on nullification written in 1834. I have hyperlinks to these original source works in the last paper on my website. I urge everybody to read these original source works by Madison for themselves. Madison is the one who said that ultimately the states have the right to determine the constitutionality of acts of all 3 branches of the federal government.
He also said in that same report to the Virginia State House of Delegates, the declarations in such cases are expressions of opinion, speaking of the Virginia resolution that he had drafted himself, which had said that the Alien and Sedition Acts were unconstitutional. He's speaking about his own writings. He said those are expressions of opinion, unaccompanied with any other effect than what they may produce on opinion by exciting reflection. Expositions of the judiciary, on the other hand, are carried into immediate effect by force. The former, speaking about the Virginia resolution of the state, may lead to a change in the legislative expression of the general will, so that hopefully they could change the opinions of Congress and the expressions of the opinions through congressional law. However, he said possibly even to a change in the opinion of the judiciary. The latter, speaking of the judicial decisions themselves, The latter enforces the general will. That's exactly what he said in that report.
Okay. You are reading from Madison's report on the Virginia resolutions written in 1799, 1800. Are you reading his discussion of the 7th and 8th resolutions? Are you? Is that a yes? Okay. In the 7th and 8th resolutions, all Madison was talking about was that the states have the right to get together and discuss this and object. That was not the meat of it. The meat of what he said is in Madison's discussion under the 3rd resolution, and that is the one which I quote at length in my paper. James Madison rebukes nullification deniers. So you're reading from a point which isn't relevant. The main discussion is under resolution number 3.
When he begins talking about that, it does begin to read as if he's talking about he's favoring the ideas of states having power until you get to his conclusion, in which case he says, no, these are actually just expressions of opinion, and it's the
Right,
court's decision which are enforced through effect.
No, he's talking about how the states can get, it isn't a matter of personal opinion, it's fact.
What question did the Civil War answer?
The question it answered was whoever has the most power wins.
And who had the most power?
Obviously, the North.
Well, I am not an expert on military strategy.
Who won?
Bad guys.
Who won?
That doesn't answer anything about whether or not states can nullify lawless usurpations of power by the federal government.
So the Civil War did not answer any question.
May I address this? Are you suggesting that
Sorry.
if I'm sorry.
I'm sorry. I've got one last question for Ms. Huldah, and then we'll get to you. Yes.
Well, I hope someone will ask me about nullification crisis.
Yes. And so the Civil War did not answer any questions.
Are you suggesting that because the North won, that the rest of us, that all of the country for the rest of our lives must submit to everything the federal government does?
Can you point to one shred of evidence post 1865 that supports the idea that nullification is legal?
This is the Constitution that was ratified. It is not something which changes with the whims of judges. That is the complaint I have, that for 200 years we have this body of constitutional precedent which has been built up, which has nothing to do with the Constitution.
Okay. Thank you, Ms. Huldah. Senator Overby and then Senator Campfield.
Well, thank you, Mr. Chairman. I really didn't catch the witness's name.
Publius Huldah. When the Federalist Papers were first published in newspapers, even though they were written by Hamilton, Madison, and Jay, they were published under the name Publius. And Huldah, of course, is the Old Testament prophet at 2 Kings 22. The book of the law had been lost, but then it was found when the renovations were being made to the temple. And King Josiah said, well, take it to Huldah and see what she says. And she said, this is the law.
So is that that's an assumed name?
That is my nom de guerre, my pen name.
What is your name?
You know, you make me out to be a fascinating person. I'm just a little old lady who was puttering around in her garden studying biblical Greek until 4 years ago when I saw what trouble we were in. So I got my copy of the Federalist Papers, dusted it off, and started writing about the original intent of the Constitution. Nothing is about me. It's about our Constitution. It's about our country. So let us stick to what's important, not about personalities, because they are not important personalities. Our country is.
I would agree with you.
Thank you, sir.
But this is not about, you're right, this is not about personality. But Mr. Chairman, every witness that we who has testified since I've been in this General Assembly has identified themselves and who they are and where they from whence they speak. And that was simply my question, to get it on the record as every other witness has done. Thank you for the opportunity to ask, Mr. Chairman.
We'll hear from the sponsor and then Senator Campfield.
I just wanted to say that the chairman and I had an understanding about all of that. So,
Senator Campfield.
Thank you. Either of the witnesses, can you tell me, did the Civil War itself end slavery? Or did the constitutional amendment end slavery?
Technically, it would be the constitutional amendment, the 13th Amendment, because the Constitution provided for it until the 13th Amendment. That was what fixed the defect.
So it wasn't the war itself did not fix it. It was actually the changes to the Constitution brought by the people, brought by the states, that actually changed it. Is that
That
correct?
is correct, sir.
Thank you. I have some other questions, but I have a question. Can you tell me a little bit more about the case of 1832 that you were referencing earlier?
Yes. Thank you, sir. My favorite question. In the 1820s, South Carolina was an agricultural state. She produced cotton. She bought her manufactured goods from England. England bought Southern cotton. Now, there were infant industries in the Northeast who were manufacturing some of the same goods that England produced, but the domestic goods were more expensive than the English imports, so they couldn't compete. So in 1828, Congress passed the Tariff Act of 1828, which imposed a high tariff on the English imports. This made the goods too expensive for the southern states to buy, so they stopped buying them. English retaliated by stopped buying southern cotton, and this greatly weakened the southern economy. South Carolina attempted to nullify this. She developed a peculiar doctrine of nullification, which said that any state could nullify any federal law, and the nullification would be presumed to be valid unless 3/4 of the states in the convention said that the nullification was not valid. Now, James Madison opposed South Carolina's doctrine of nullification, and this is why. Article 1, Section 8, Clause 1 specifically delegates to Congress authority to impose tariffs. And further, it requires that the tariff be uniform in all the states. So we couldn't have a situation where South Carolina was paying no tariff, but the other states were paying the tariff. So South Carolina tried to nullify a constitutional law. That was the determining factor in this, that the Tariff Act of 1828 was fully constitutional. So in 1834, James Madison wrote lengthy notes on nullification, and he pointed out, 1, the Tariff Act is constitutional. States cannot nullify a constitutional law. 1/4 of the states don't have the right to dictate to 3/4 of the state on matters which are in the delegated powers of the federal government. And finally,
I'm so sorry to interrupt you, but we only go until 1 o'clock. So if you could just keep your answers as short as possible, that would very much help us out. We have Senator
I
Stevens.
still have a question. I have 2 more questions before I'm done with it.
Okay, very quickly.
Okay.
We got Senator Stevens, Senator Green, and then we'll be done.
Okay, very briefly, what do you think was the purpose of the 10th Amendment? And we talked about what the Constitution has been, how the Constitution has been changed. Has there been any constitutional amendments that removed the 10th Amendment that I missed somewhere?
no.
Okay.
No.
What is the
Senator
purpose for the 10th
Campfield, last
Amendment?
question.
Just to make it clear that the Constitution we ratified, the Constitution everybody voted for, is one of limited enumerated delegated powers. Depending on how you count, only 21 powers were delegated to Congress. None of them is the right to restrict our arms. The purpose of the amendments was just to reassure some of the states who were nervous about the federal government having too much power. And the 10th Amendment says, you know, we really mean it, where we enumerate the powers in here. We really mean that that's all they have, and that the federal government has everything else. James Madison discusses this the best in Federalist number 45 at the fifth or the ninth paragraph.
Okay.
Thank you very much.
Senator Stevens.
Yes, Mr. Chairman, thank you. The examples of overturned nullification mentioned by both yourself and the AG, at least as I've looked at them, all seem to be examples of states attempting to nullify federal law that was in fact constitutional. Are there any examples of overturned nullification efforts where the federal law was unconstitutional? And that's a question to either the witnesses or yourself,
Well,
Mr. Chairman.
my problem is that we're getting into circular reasoning here. The witness stated that South Carolina nullified the act, but that the act was constitutional. Well, that's the whole question: is who gets to decide whether it's constitutional? And if the testimony is that the states get to decide it, then the state decided. So
Well,
I think that ends the question. But I'll let the witness answer your question.
Well, sir, that's very easy. Article 1, Section 8, Clause 1 delegates to Congress authority to impose a tariff.
Obviously, it wasn't very easy for South Carolina. And the
No,
convention
South Carolina
disagreed
said
with
you
on
can
that.
nullify
You've said that they have the
constitutional
final-
laws.
Excuse me, I'm sorry. And that they said that they have the final authority on that. But let me go back to Senator Green.
Yeah, Mr. Chairman, if I could, though, nowhere in our history has there been an attempt to nullify federal law that was unconstitutional. So we don't really have a record, right? And nowhere in the Constitution does it state otherwise that states can't. Other than you would cite the Supremacy Clause.
I am not trying to dodge the question, but the question really is circular because you're assuming that you personally have the ability to determine constitutionality. And what I'm asserting is that the Supreme Court, according to Madison, had the ultimate, no, not in Marbury versus Madison, according to Madison himself in the Federalist paper. I'm sorry, Hamilton in the Federalist Papers, Madison himself in his report to the Virginia House of Delegates, and then also Marshall in the Marbury versus Madison, they said the court did, and that's
Correct,
sorry,
sir.
I know we disagree on that, but Senator Green.
Yeah, if I could also state, I do want to bring up one Supreme Court case very quickly, if I could. It's a case called Reed versus Covert. In this case, Miss Covert was the wife of a military soldier assigned to England, and while she was in England, she killed her husband. The United States had a treaty, which, according to the Supremacy Clause, essentially makes it equal to the law of the land. And that treaty should, per the Supremacy Clause, have had priority. However, the court's opinion stated that the Fifth Amendment and the Sixth Amendment essentially overrode the Supremacy Clause. They limited the Supremacy Clause because they were limits as a part of the Bill of Rights on the federal government. So it would seem intuitive then that so would the Second Amendment.
And with all due respect, that is a misunderstanding of the Supremacy Clause. The Supremacy Clause says that the Constitution is the supreme law of the land, and that acts of Congress and including treaties that are ratified by the Senate, that are entered into in pursuance of the Constitution, are also valid federal law. However, they cannot be trumped by the Constitution, and that was the issue in this particular case. The court ruled that the Constitution itself, and in this instance the Fifth Amendment, is what had prohibited that particular treaty from being supreme, from being enacted in pursuance of the Constitution itself, and that was the issue. In that
Right, and I guess I misspoke. The point I was trying to make is that from a pure reading of the Supremacy Clause, and it does say in pursuance, I understand that, but the Bill of Rights and those amendments do, because, as they are part of the Constitution, make any effort to usurp them inappropriate and unconstitutional. So any effort with the Second Amendment, whether it be a state law or a federal law, that is unconstitutional according to those amendments, I think we have a right to stand opposed to that.
Senator Stevens.
Thank you, Mr. Chairman, and thank you for your testimony today.
Yes, sir.
When you made the statement that the adoption and the ultimate power lies in the states or something to that effect,
Yes, sir.
correct? When you say that in reference to the founders as well, didn't they put that in the Constitution in Article 5 of Section 3?
Ms. Huldah.
Don't the states act upon the Constitution by ratifying amendments to the Constitution?
That's one way, but that does not preclude, according to James Madison, Thomas Jefferson, and Alexander Hamilton,
But-
nullification.
But
Senator Stevens.
the Federalist Papers weren't adopted by the states, correct?
No, sir, but they were considered as the most authoritative commentary on the original intent of the Constitution until Charles Evans Hughes said, the Constitution means what we say it means.
Well, but the Constitution was adopted by us,
Right,
people,
right.
through the amendment process, correct?
Well, through ratification.
Right, but not the Federalist Papers.
No, but the Federalist Papers were considered authoritative on the genuine meaning. It's like advertising. These Federalist Papers were used to explain the proposed Constitution to the people and induce them to ratify it. So it's like advertising. This is what we were promised.
So you're asserting that outside of Article 5 or Section, outside of Article 3, Section 5, the states can act to amend or to change the Constitution outside of Article 3, Section 5?
No, sir. What I'm saying is that when the federal government makes a clearly usurpacious law, such as restricting our firearms, it is the duty of the states, imposed really by their oaths of office, to support the Constitution and to defend the Constitution from the attacks on it by the federal government. And that is what our framers said.
But didn't we enact that the judicial branch would rule something constitutional or not? And then if we disagree, we the people disagree with that ruling, we can change the Constitution through the amendment process. Isn't that what we adopted?
No, sir, that is most manifestly not what we adopted. What we adopted was a Constitution where the Supreme Court is every bit as subject to the terms of the Constitution as the other two branches. We, the people, are the creators. The federal government, including the Supreme Court, are merely our creature, and the Supreme Court is completely subject to the terms. And our framers understood that Supreme Court judges might usurp powers. That's why Congress has the power to impeach and remove them for usurpations.
We're down to about
Thank
about
you.
two
Thank you for your
minutes.
testimony. Thank you, Mr.
Thank
Chairman.
you. Senator Gardenhire, last word.
I would love to hear the sponsor of this bill say some words.
If you would, please keep your seats here. Thank you. Yes. Senator Beavers, would you like?
Senator Bell, I don't know if you want to recognize him first.
Senator Bell.
Mr. Chairman, I do have something I want to say, but prior to the time we take a vote, do we plan on taking a vote today?
Yes, right now.
Okay, I want to, when we go back into session, my question or my statement is not to them, but when we go back into session, I'd like to be recognized.
We are back in the session. Senator Bell, you're recognized.
Thank you,
And
Mr.
thank you
Chairman.
for your testimony. I really do wish we had more time to explore these issues. I really do.
No, we do.
They're very interesting. Thank you for your testimony.
Mr. Chairman, I have truly been fascinated by the discussion going on for the last hour, I guess, 45 minutes to an hour. I feel like a lot of the discussion has been up in the clouds, and I don't mean that in a demeaning or derogative way. Just it's been a very intellectual, scholarly discussion on your part and the research that you've done, and on the part of the witnesses. I've got a couple things that I'd like to say before we vote, and I would like to make a statement directed at and I'm in favor of this bill. I'm going to vote for this bill, but I do want to call out some of the people who have been, I think, saying some very unkind things about the chairman and other people who have legitimate problems with this bill. Political discourse has to be civil. It has to be. And I've received some of the emails, and I've been copied on some of the emails that I know the chairman has received. And political discourse has to be civil, even when we disagree. And Mr. Chairman, I wanted to point that out. I thank you for your leadership on this committee. The chairman earlier referenced the opinion of Chief Justice Roberts in the case concerning the Affordable Care Act. And I found at least a couple of quotes from that opinion relevant to this discussion. Chief Justice Roberts quotes Chief Justice Marshall nearly 2 centuries ago when he says that the question respecting the extent of powers actually granted to the federal government is perpetually arising and will probably continue to arise as long as our system shall exist. We're here today with one of those questions. We have a question that arises: where does the power actually lay concerning the regulation of firearms? And there are different opinions on this committee. I agree with the sponsor and the intent of her bill that it should be with the states. I would also like to point out that the Supreme Court, as has been pointed out, has made numerous decisions over the years, and later Supreme Courts have overturned those decisions. I looked up just a few. Lochner versus New York was overturned by Adkins versus Children's Hospital. Adler versus Board of Education was overturned by Keysishan versus Board of Regents, University of New York. Pace versus Alabama was overturned by Loving versus Virginia. Austin versus Michigan State Chamber of Commerce was overturned by Citizens United versus the Federal Election Commission. Wolf versus Colorado was overturned by Mapp versus Ohio. Plessy versus Ferguson was overturned by Brown versus the Board of Education. I bring those out just to again reiterate the point that the Supreme Court is not perfect. The Supreme Court constantly over the last 2 years has overturned itself and corrected earlier decisions. Mr. Speaker, thank you.
Thank you. Thank you for your words. Senator Campfield, if everyone could remain brief. Thank you.
Thank you. I will. Seeing as there is testimony and questions still being out there, and as I believe Senator Beavers would like to bring amendments, I move we adjourn until next time.
That's a proper motion. Is there a second? There is a second. We'll do this on a voice vote. All those in favor signify by saying aye.
Aye.
All opposed, no. No. In the ayes of the chair, the motion fails.
I would ask for a roll call vote on
Roll call vote on the motion to adjourn.
Senator Bell? Votes aye. Senator Campfield? Votes aye. Senator Finney? Votes no. Senator Ford? Senator Gardenhire? Votes aye. Senator Green? Votes aye. Senator Overby? Votes no. Senator Stevens? Votes no. Chairman Kelsey?
No. 4-4, the motion.
Thank you for watching. I want to turn you on to that. I caught that today. Somebody posted over on TikTok and put it in the Fearless Floyd show, and I went and did my investigation, found out who she is and what she's all about, and I have reached out to her and given her a formal invitation to come on the show. I definitely would look forward to that conversation. So stay tuned. I don't know when I'm going to have her on here. I just heard from Noel Benoist. He's back from Washington, D.C. on his little jaunt over to meet with the Trump administration. So he's back in Reno. He's got to take care of some stuff this weekend. We'll get together early next week and get him back on the air, tell some more of his crazy stories. As a man in black, Majestic 12 NSA whistleblower, he has quite the catalog of stories. Also, I have Raymond back on. Him and I have been working together to get this trust stuff finalized, and we've almost got it. So we're having that. If you haven't noticed, I do have a Memorial Day sale, and you can check that out. I don't know why that's not coming on. There we go. 50% off on select items over in the fearlessfloydshow.com store. Go check us out. I'll be adding some more stuff over the next 30 days or so. The Memorial Day sale runs till the end of May. So save up your money, go get you a credit card and get involved. Get you a book, get you a class, get you a package, whatever you need. Get you some merch. All the shows that I've been doing live, I've been giving away books. I've been giving away classes, T-shirts, et cetera, et cetera. So tune in, get you some free merch. We do it through my Telegram, so it's 100% transparent. You can actually see the number when I tell you, caller number 10. It's the same principle. So you can see it in real time for yourself. So there's no shenanigans. I've had people actually hit for the cycle. They won everything I put out there. Yeah, I know. Yeah, and if I would have done that behind the scenes, y'all like, oh, he's playing favoritism, but I didn't. So, gonna have some more guests coming on, some new ones. I'm reaching out to as many people as I can that really aren't on other people's social media platforms, just like the one we just saw. So if you have any guests, topics, or anything else that you would like me to go investigate and bring those people on or solicit them, or vice versa, go ahead and do that. You can always reach me at the Fearless Floyd Show at yahoo.com. My website's thefearlessfloydshow.com, and I'm pretty much the Fearless Floyd Show everywhere. Okay, the Fearless Floyd Show on all social media platforms. So come find me. Mainly I hang out over on Telegram because I can move 4 gigabytes of data at one time. And I just went through this with Raymond about sending stuff. I go, you got a Telegram account? No. Well, I don't really feel like sending you 12 emails or a zip file, hoping you can unzip it. So that's why I use Telegram, because I can send you this video right here instantly, and you'll have it and be able to watch it. That's why I use Telegram. All the other crap, really don't care about what goes on over there. I just use it as a platform because it's very utilitarianism for my show. All right, so the Federalist Papers, that seems to be where we really should be studying, to go back and get the true narrative, meaning, definitions, context of what the framers of the Constitution actually were trying to do when they wrote the Constitution. Because now, as I said, folks, at least 7 justices on the United States Supreme Court are fucking insane. They've lost their damn minds. I'm telling you, the entire system has been hijacked. We've allowed it to get hijacked. It has metastasized into a cancerous, parasitic monstrosity that's uncontrollable, and nobody can hold it to account. Obviously, Congress is compromised. Obviously, the judiciary is compromised, and that leaves nothing but Trump. When we talk about there has to be some major arrest, we're talking just, mind-blowing arrest. Yeah. It wouldn't surprise me a bit if all 9 Supreme Court justices were taken into custody, but at least 7 for sure. Wouldn't surprise me at all. And until that happens, until this is turned into a military operation, far beyond the own federal government, because there's only one commander in chief. And if he declares an internal war, all the enemies, foreign and domestic, waging war against the Constitution, which is the ultimate document. And we've allowed these courts to go in and parse and amend and twist everything, legislative intent to, they splinter it, or they just waive part of it. Who cares? They got enough of it right. They didn't complain about it, so they waived it. That's how they look at it. And I'm telling you, if you continue to do what you do and rely on the electoral system to continue to churn out these knuckleheads to run your state, to run your county, to run your parish, to run your city, your township, whatever that looks like. You see a little old lady out gardening and something got her attention and she went and put her nose to the grindstone and went and got educated and then went in there and clowned the entire state of Tennessee. Clowned them. Made them all look like blithering idiots, buffoons. It was a clown show. So, and I know her real name. I know her married name. I know who she's married to. Come on, y'all got to already know. If I really wanted to go dig some more, I would have gotten her cell phone number and called her directly, but I was courteous enough to send an email invite. So you guys stay tuned. I got another video coming up tonight at it's 16 minutes. So y'all stay tuned for that one. That's basically a replay of the first 45 minutes of the video that I did last night when I was talking about all the stuff that I did in prison. Mainly it deals with the current Texas House bill that they passed to put air conditioning in all Texas prison units by 2032. Impossible. Impossible. Never happened. And they're going to spend, oh my God. Go on. If you want to go bid on those contracts, you should, because trust me, there's going to be shit tons of cost overruns and it's going to balloon. It's going to be like a federal contract, like a defense contractor, Yeah, we're going to charge $5 for a hammer. And then you get the bill and it's $500. And they sold you 10,000 of them. You only needed 2. That kind of stuff. All right. Thank you, everybody. Y'all go enjoy your weekend. Stay tuned for the show tonight. If you don't, I got a 6-minute outro coming. So if you want to bail now, be sure and like, subscribe, share, hit that notification bell, leave a comment below. Tell everybody what you want to know. If you want a book and you've actually one of Ann's trust books and you've already shed through it, or the 200-year plan, I gave that one away as well. Hey, man, leave a comment below. Tell me what you think. If you liked the book, didn't like the book, if it was great, I'm just proud to be able to do that. Very humble. So thank you, everybody. I'll see you at about, 15 minutes, but I won't be live. That is a pre-recorded video. I will be back, though, Monday, 6 p.m. Central Standard Time. I will have Raymond on there, and I may just have some other guests. Who knows? I know he's setting up some stuff. He has a lot of connections like I have, so we're going to try to do some good presentations for you guys. Thank you very much. I know I'm waiting on the email, just in the 800 number, just like y'all guys are, and I don't have anything new. I did hear from Elizabeth. She sent me a telegram. Nothing on her part. Still have not heard from Jeff Rom. So all quiet on the RV front. So I'm sitting here waiting just like you, and you will not hear about it. Thank you, everybody. Thank you for hanging around to watch this special promo on the new book by Ann LaFleur and Fearless Floyd, Specialty Trusts. We'll dive right in. There's the cover to the On Trust books. That's the first book that Ann wrote. This is the third edition on revocable, irrevocable, foreign, charitable, remainder, express, college education, and land trusts. It has instructions, templates, examples, everything you need in this trust or in this book to run these 7 different trusts. Everything you need. Here's the table of contents. And please disregard the error bookmark, not defined, notices on the right hand of the screen. There is a lot of redundancy in this book simply because the simplicity of how it was adopted from the classes. So you're going to see, a trustee appointment letter in every one of the trusts when you just really need one and just change the information. Here we go. This is a specialty trust cover. And here are all the trusts that are available in this book. How to create and operate specialty trust, full instructions, templates, and examples to create and operate. A Q-tip, a qualified terminal interest property trust, qualified personal residence trust, irrevocable life insurance trust, third-party special needs trust, community property trust, asset protection trust, discretionary trust, ministry trust, decedent trust, charitable trust, special needs trust, perpetual family trust, testamentary discretionary trust, grantor retained annuity trust, irrevocable farm trust, pets trust, AB trust, and marital trust, as well as the bonus DNA trust addendum. Here is the table of contents. And again, please disregard the error bookmark at not defined. And here we go with the DNA trust. Wanted to show you guys a little bit of this. That's the first 3 pages right there. This is the bonus. You can add this to any one of the trusts. Doesn't matter whether it's a revocable, irrevocable, foreign, express, pets trust, same thing. If you'd like to get one of the books or a combination or a package, the ebooks are available for $249 each, and that's either the on trust or specialty trust books. If you'd like a soft cover, they are $259. I do have package deals available at thefearlessfloydshow.com/store on my website. If you'd like to do an a la carte package deal that I don't have available and you want to put something together, hit me up, thefearlessfloydshow@yahoo.com. I mainly hang out over on Telegram, so come hit me up over there. These 2 books are probably the only books you will ever need if you ever want to operate in trust, and everybody should at least research it and see if it's right for you and your family. Thank you for watching, everybody. I appreciate it. And I'll see you at the next show.